Hi, this is Payton Hoover, litigation attorney with Campbell and Associates, here today to talk a little bit about damages. A question I quite frequently get asked is, if I go to court, what am I allowed to ask the jury for? And essentially, in most cases, there are three things. The first being medical bills. That includes prescription drugs. The second is any time you lost from work, or lost wages. And the third is pain and suffering. I'll go through each of those very briefly here. Medical bills. That's the amount of the medical bills that are reasonably necessary to treat the injury that you sustained. It used to be that you'd submit the full amount of the bill. Whatever the hospital or doctor charged you, that would be the amount that you would be able to submit to a jury. On October 1st of 2011, as a part of some sweeping tort reform here in North Carolina, the law changed. Now, you're allowed to ask for the amount of the medical bill that was either paid or that is outstanding. So, when health insurance, Medicare, or Medicaid pay on a bill, there is always an adjustment to that bill. They never pay the full amount. And the amount that's adjusted off that bill, under the old law, you could ask for, or you could submit to the jury. Under this law, you cannot. The amount that you are allowed to submit to a jury is the amount that was paid either by you, Medicare, Medicaid, or private health insurance, and the amount that's still owed if there is an outstanding balance. This is important because it affects that third element of damages, which is pain and suffering. Whether right or wrong, juries tend to equate pain and suffering with medical bills. And the lower that the insurance company can get those medical bills, the better chance they have of getting a fairly low verdict when it comes to pain and suffering, that third element of damages. There are ways to combat this, and it's important that you speak with an attorney to come up with a game plan, especially if your medical bills, because you have Medicaid or Medicare, are relatively low. The second element of damages is the lost wages. Now, that can include time that you've missed going to doctor's appointments, and it also includes time where you've missed work because a doctor has taken you out of work because you're unable to perform your daily duties. It is important that you keep track of this and that you also have your employer keeping track of it and substantiating it for you through some form of affidavit. Again, something that an attorney can also help you out with. The third element is the pain and suffering, and that's the part where we don't have a receipt. It's ultimately whatever 12 jurors come up with. And a lot of times they're equating your pain and suffering with your medical bills. And it shouldn't be that way because there's no correlation there whatsoever. But it's an easy thing for them to do. It's an easy thing for them to say, well, he or she has $5,000 in medical bills. Let's put another $5,000 on it for pain and suffering and get out of here. When a lot of times the pain and suffering portion of the claim is substantially more valuable than whatever was paid for the medical treatment. But that's where we are here in North Carolina. In South Carolina, they operate under the old way of doing things here in North Carolina, where you are allowed to submit the entire amount of the bill, and the at-fault party does not get the benefit of you happening to have health insurance or Medicare or Medicaid. Until next time, be safe out there. If you run into somebody that isn't, feel free to give us a call. We're licensed in North and South Carolina, and we're here to help. Thank you.